Good afternoon, students. Today we will discuss Ronald Dworkin's taking right seriously. Uh, you know, the language of right is always or has been, uh, I mean, uh, it has been dominant in the political discourse. Right. Uh, Rights to the individual is very much essential, primarily because uh, it helps individual to realize his or her own potential, right? And when you exercise your rights, then the same rights are also, it belongs to the other, right? So who can, I mean, what are the major characteristics of right? I think there are three major characteristics of right, or rights constitute three elements. One is the power of the individual. Second is the recognition by the society. And third is the sanction by the state. Uh, you know, rights are given to the individual, but do that right, given right, uh, helps the individual to realize his own potential, right? This is a question. I think rights are there. Some people enjoy rights and some people don't, or they cannot enjoy the right. It because some people are in powerful position. Either they are, you know uh, basically here powerful means they are psychologically, they are powerful. When I'm saying psychologically powerful, either they're economically powerful, or they are socially powerful, or they are politically powerful, right? So until and unless you do not realize your own power, you do not, you know uh, think yourself that you are the capable person, you should assert your right. You cannot enjoy your right, even though rights are given to you, but you may not enjoy those rights. So the power of the individual, especially the psychological, in psychological sense, that is very much essential uh, for rights to be used for developing human potential. And the second aspect of right is the you know recognition by the society, right? I mean, uh, and I mean, when the society will recognize your right, only when your right produces some social values, then only the society, it will accept your rights. Otherwise society will put question mark, right? I mean, the right what you enjoy, that is also uh, applicable to other individual. I mean, if all individual enjoys that right, uh, in consequence, does it or will it produce good for the society? So specifically, or specially, uh, society recognize your right only when your right produces the social values, right? And the third is the sanction of the state, right? uh, if there is any violation of your right, then some institution which can punish the violator must be there, right? So state plays that role, right? So state sanction the rights, right? State is the institution which punishes the violator of rights. And why, I said the character of right or the constituents, uh, I mean, constituents aspects of right, it is because, state uh, is a important, uh, you know, state is a important component of right, right? Now the question arises, and I mean, when the state will sanction the violator of right, only when that right is legal, only when that right is legal. If you are within the law, you are in accordance to the law, and someone breaches your right, then you go to the state will punish that person. So in that sense, state is the final authority of your right. Right. So when we see right from the state perspective, it becomes the legal right. But the next question is that if the state violates your right, then what will you do? If you define, right from the state sense, then you understand it as your legal right. But when we talk about right, does it limited to legal rights only? If the state violates your right, what will happen? Right? So this is a very serious question. And in this context, Ronald Dworkin is a very, very important philosopher. Right. In his book, Taking Right Seriously, he has defended how individual rights are fundamental. How individual rights are fundamental. In no circumstances, individual rights cannot be or should not be violated. Even the common good or collective good cannot be the obstacle or barrier of individual's right. How Dawkins has defined right. Now, to Dawkins, rights are moral entitlement. Rights are moral entitlement which we possesses, which we possess as being, or which we possess being, or which we possess uh, as being with self-respect and dignity. Right. So to Dawkins, rights are directly connected with self-respect and dignity. Right. If you do not have any rights, then you do not have any self-respect or dignity. Right. Now, should we surrender our self-respect and dignity to the state? To Dawkins, we should not, because the state may go against your self-respect or dignity in some situation. Right. That is the fear in the mind of Dawkins. State understand rights in legal term, but rights, the term rights is not legal, it is beyond legal. And to Dawkins, it is moral. Moral is something it is it's a broad concept, right? What is legal today, it was moral yesterday, and what is moral today, it may be legal for tomorrow, right? So Dworkin understand right in moral sense, not in legal sense, because I said the second important aspect of right is the sanction by sorry recognition by the society. Now society, I said, society will recognize your right only when your right will produce values for the society, right? Now here there is a connection. Why we should think rights in moral terms? Why we should think rights in the moral term? It is because morality is deeply connected with the values, ethics, and morality is deeply connected with the concept social, society, right? Let me give you an example. In India, uh, IPC, Indian Penal Code 497, deals with adultery. Earlier, the provision was this, that if you are having extramarital affair, then you will be punished if you are a man, and if you are a woman, then you will not be punished. It was the provision earlier in IPC 497. But when this adultery law, you know, got reformed, after the reform, the adultery law was delegalized, right? Now, in the new provision, if women are not punished for adultery, for their involvement in the adultery, so also men will not be punished. So it becomes a legal right for the couples to go for extramarital affairs. Now it is their legal right? Because it is not an offense. Extramarital affairs, it is not an offense. So from legal sense, it is a just act. But if you see it from the social perspective, from the perspective of society, then it is deeply problematic. Deeply problematic. Because society exists with some values, and these values must be related with unity, integration, some kind of bindingness, commonness, right? Now if individual exercise their legal rights in connection to adultery, then society gets disintegrated, because this adultery is a direct attack to the family system. Family may not exist, togetherness may not be possible, and family is the foundation of the society. Recently, something has, you know, There are many incidents relating to adultery is happening, and gradually we are realizing how society is negatively affected, right? Recently, I will not take the name, but I will describe the event. Recently, the wife of a faculty in a university, that wife, entered into the chamber of her husband, and he, sorry, she locked the room from inside and started beating her husband with her sandals, right? And what is the issue? The issue was that her husband was in the, I mean, she was doubting, or she, had some evidence. Her husband was with a extramarital affair. Now, if you see from the legal perspective, then it was not a crime in case of her husband, but certainly it was a crime on part of that wife, because in the perspective of law, beating someone is illegal. Now the question arises. Now the question arises. Can the society accept what is accepted by the legal system, or what is accepted by the law? Now the society may accept the position of that wife. Society may become critical about the husband, but law is critical about the wife, not about the husband. Now, this is the problem. This is the tension. From societal perspective, the husband is the culprit. The husband has gone against the social values. And from the legal perspective, the wife. Now, in such a situation, how we should think about our rights? Should we think our rights in legal terms, or should we think our rights in social terms? Because both society and state is very, very important in the execution of right. Very, very important. Now, to Dworkin, there is problem if we think rights from legal perspective. Rights, that doesn't mean that Dworkin is against the legal right. Dworkin is saying rights is legal and rights are also beyond legal, because rights are the moral entitlement, and rights are required to protect the self-respect and dignity of the individual. So self-respect and dignity may be protected by the state, or it can be, violated by the state. Now, if it is violated, then to Dworkin's right becomes the claim against the state. Now, if the state unable to protect the dignity and self-respect of the individual, then To Dworkin's, if state violates the individual's right, if the state goes against the self-respect and dignity of the individual, then to Dworkin's, individual must have rights against the state. So self-respect and dignity is violated when individual needs and preferences are sacrificed simply on the basis of collective welfare. Right. Now I can remember about James Stuart Mill, that one individual can be right, 99 individual can be wrong. Right. So to Dworkin's, if the self-respect and dignity is an important component of rights, then individual rights should not be sacrificed in the name of collective welfare. Right. If my rights are sacrificed due to the common good, collective welfare, then that collective welfare or common good does not consider my self-respect and dignity. Hence, if the collective welfare goes or precedes before the individual right, then to Dworkin's, then individual do not have rights. So when we say individual have rights, it means individual right must precede the collective welfare. The collective welfare should not be imposed on individual right. Rather, it is vice versa. The individual right should be imposed on the collective welfare. So if I have rights, then it means, and if the state protects and promotes my right, then the state cannot force me to sacrifice my right for the collective welfare or common good. Right. So this is the position of Dworkin's. Now Dworkin regards that legal process as a matter of principle oriented towards viewing our relation with other in terms of justice, and the political process deals with the policy based on the promotion of general welfare. So here Dworkin is saying whether it is legal process or political process, in both these process we find that the collective is more important than the individual. In the legal process, it is a principle. I mean, in legal process, all these laws, regulation, principles, all are oriented towards viewing our relation with the other in terms of justice. That means individual himself or herself is a non-entity. In legal sense, all these principles has been designed in order to maintain individuals' relation with one another on the values called justice. On the basis of justice, individuals' relations, individuals' relation has been defined in legal sense. And what happened in political process? In political process, to Dworkin's, it also deals with the promotion of general welfare. Politics is all about common good, general welfare. Now in both the process, legal process and political process, there is no individual, there is collective. There is collective in the form of either justice or in the form of common good. Right. Now, Dworkin, he is against this. So, Dworkin argues against the ruling theory in Anglo American law, that is what we call legal positivism. So, Dworkin, he was against the legal positivism and economic utilitarianism. Right. He asserts that individual has legal rights. I have said it before. But individuals are not limited to the legal rights. Individual has rights beyond the law. So individual has legal rights, and beyond it, they have political and moral rights against the state. Right? So if the individual is having rights against the state, if the individual is having right against the law, against the politics, then it means individual are actually having the rights. If individual cannot have rights against the state, against the law, if individual rights are limited to the state, if their rights are only legal, then to Dworkin, individual in actual sense do not have any rights. So individual has legal rights, and beyond it they have political and moral right against the state that are prior to the welfare of the majority. Right. So to Dworkin, individual rights, individuals political, moral and legal rights are prior to the welfare of the majority, are prior to the collective welfare. Through an analysis of John Rawls' theory of justice, Dworkin argues that fundamental among political rights is the rights of each individual to the equal respect and concern of those who govern him. Right. Now, from John Rawls, so Dworkin, while analyzing the theory of justice by John Rawls, he understood that rights or rights of each individual, rights of each individual is justified only when the same rights are also available to the others. To him, individual liberties are derived not from some abstract right to liberty, but from the right to equal concern and respect. Right. So what he's saying, that the rights should not be derived from abstraction. Right. So right to liberty For Dworkin, it's an abstract idea, right? But right to equal concern and respect, that is the main aspect of the right. That is the main aspect of the right. Thus, Dworkin denies that liberty and equality are conflicting ideals. So, while analyzing John Rawls' theory of justice, Dworkin's got a sense that liberty and equality are not conflicting ideals. Liberty and equality are not conflicting ideals. It's because rights means right to equal concern and respect. Right. Equal concern and respect. So let me take 1 minute breath and come back. So welcome back. So Dworkin, liberty and equality are not conflicting ideals because rights means right to equal concern and respect. Right. And individual right exist independent of legal positivism. Right. Now, what is that legal positivism? Why Dworkin is saying individual right must exist independent of legal positivism? Now, to legal positivism or legal positivism holds that the law is made up by the majority. And when I'm saying majority, it is collective. And the Supreme Court identify and enforce right, but it does not create them. Right. So to legal positivism, law is made by the collective entity that is called majority. And the Supreme Court, to legal positivism or according to legal positivism, the Supreme Court identify the rights and enforce the right, but it does not create any rights. So to legal positivism, rights exist within the law. Right exists within the law. To legal positivism, rights means legal rights. So a right exists. Now, Dworkin is critical about the legal positivism. Legal positivism limited the right within the law. But Dworkin is saying if the rights are within the law, If state is the final authority over your right, then you do not have any right. Now to him, to Dworkin, a right exists when a person claims to do something, overcome any contrary collective goal. Right. Now to Dworkin's, individual right is there only when individual can go against the collective goal. Then only individual has right. Now if the law is made by the majority and individual cannot go against the law, it means individual cannot go against the majority, then individual do not have any right. Right. Further, Dworkin said that if the law violates the right, if the law go against the self-respect and dignity of the individual, then individual have the right to disobey the law. Right. Now, Dworkin's taking his argument further, that judge may go beyond the law to see the authenticity of right or existing law. Thereby, the judge arrives at a decision that create a new law. Now, to legal positivism, the judge cannot create law, but to Dworkin, the judge can also create law. How? The judge will see the authenticity of the law. The judge will see the authenticity of the right. If an individual has gone against the state, against the law, then the Supreme Court, the judge will see what is the authenticity the of the action of that individual. What is the authenticity of the existing law? While giving or checking the authenticity of right or law, this court or the judge, they can also create the new law. Now, if the right do not exist except for those provided by the legal rules, then it is called legal right. As I said before, right? If the right do not exist except for those provided by the legal rules, if there is no rights beyond the law, then it is only the legal rights where the state is the final authority. Legal positivists, errates in its assertion that judges and lawyers rely on legal rules when they argue and reason. Now, there is a conflict between Dworkin and legal positivists. Now, to legal positivists, the first conflict was that to legal positivists, judges do not make laws, but to Dworkin's, judges, while checking the authenticity of the right, authenticity of the law, the judges create the new laws. This is the first contestation between the legal positivist and Ronald Dworkin. The second contestation is that to legal positivists, judges and lawyers, they rely on the legal rules when they argue or when they rationalize their position. But to Dworkin's, what he's saying, but in actual practice, the judges and the lawyers, they base their justification and decision on principle, and that principle may not be there in the law. So a principle's power derives from its connection to the moral. It means the judges and the lawyers, they derive their argument, their reasoning, not from the legal rules. I'm sorry, they may derive from the legal rules, but in actual practice, you know, they form their argument, they form their reasoning from morality, right? Now, morality is a fundamental aspect of any principle. I mean, judges and lawyers, they are guided by the principle, and that principles is related with the morality, right? In actual practice, it is theoretically, judges and lawyers, uh, they rely on the legal rules, but practically they rely on morality. Hence, judges do not enjoy discretion in any substantial sense, right? So it means if the judges and the lawyers, they are guided by the question of morality, then they do not have any discretion. They do not have any, you know, discretion, power. They are compelled to give decision what is just. Now, the central tenet of legal positivism regarding judicial discretion is mistaken. Legal positivism does not reflect the reality of legal practice. Now, it is the Dworkin's position. So, Dworkin is saying that legal positivism on judicial discretion, there is a mistake. I mean, legal positivists, they have wrongly understood the judicial discretion power. Now, if you see the legal practices, one can find that judicial discretion is not there. So, judges and the lawyers, they are guided by the principles, and those principles are related with the question of morality. So, no doubt, in a truly liberal theory of law, individual possesses legal right which do not always arises through legal decision. In fact, a right exists when an individual can claim to do or have something overcomes any contrary, collective goal. So Dworkin is not against the legal right, but Dworkin is against that rights should not be limited to the law, right? If you have rights, then you can go against the collective goal, right? Now, contrary to legal positivism, A party to legal case may have the right to prevail even when no legal rules exist to indicate this outcome. It means if individuals have rights and state take care of that right, then the state will not limit that individual within the law, right? Imagine in a court situation where one party to a legal case, he or she is fighting with her opponent. Suppose that party or the position of that party do not have any connection to the law, right? So contrary, a party to a legal case may have the right to prevail even when no legal rules exist, right? Suppose the argument what I am putting forth in a court, suppose that argument do not have any legal connection. I mean, the law, in the law, there is no, I mean, there is nothing which is related with my argument, right? Even in that case, even in that case, I may win the case. I may win the case. How? Because I do have right against the state. State has made the law. I have not made the law, right? Now you see there are many cases against the state, and in many cases, you know, individual has won against the state. How individual has won against the state? It is because individual has the right. Right. So our moral practices are not exercises in statutory interpretation. It means my rights are connected with my morality, and I am guided by my morality. When I am guided by my morality, then I do not think about, I do not see the law books, right? I mean, in our, social practices, do we really refer what is there in the law, and according to that do we behave? No. In fact, our social behaviors, the just social behavior, I'm not talking about antisocial, the just social behavior, what is the base of that just social behavior? Is it the legal books, or is it the morality? It is the morality, right? Judges create new laws when they rule on, new cases. They either follow the argument of principle or argument of policy. Now, argument of principles asserts individual or group right as the rationale for a decision. I'm just reading it out, then I will make you understand. Argument of principles asserts individual or group right as the rationale for the decision. Argument of policy puts forward a collective goal as the rationale for the decision. When judges are guided by arguments of principle, they remain neutral on policy question. and thereby they ensures the rights of the individual and group. And when judges are guided by the arguments of policy, they either make policy decision or declare that policy ultra virus, thereby take care the rights of the individual or group in the second case. So what it means? I have said that judges do also create new laws, right? So to Dworkin's, either judges follow the arguments of principle or they follow the argument of policy. Policy means the decision made by the majority. Principles means morality. So when a judge decides a case, either that judge is guided by the argument of principle or that judge may be guided by the argument of policy. Argument of principle asserts individual and group right as the rationale for the decision. If the judge is guided by the arguments of principle, then the judge will, see, or the judge will examine the individual right or group right, right, in the context of morality. In moral sense, judge will examine. Even judge will examine their rights beyond the law, right? What is the argument of policy? An argument of policy puts forward a collective goal as the rationale for the decision. Now, if the judge is guided by the argument of policy, then the judge will see what is the law and how individual has gone, whether individual is within the law or individual has breached the law. Now in the first case, in the argument of principle, if the judge is guided by that, then directly individuals' rights are ensured by the court, because individual uh, rights are connected with the morality, and the principle which guides a judge while dealing with a case, that is also related with the morality. So if the judge is guided by the principle, then it serves the individual's right. But if the judge is guided by the policy, then two things may happen. Either the individual's right will be curtailed, in the sense that the individual will be said that this is the law, now you have gone against the law and you will be punished. Either this will happen, or that policy may be declared by the judge as ultra virus. Right? Here you can also understand, we have provision called due process of law and procedure established by the law. In due process of law, what is, applicable in the context of America, you will find the judges, they can go beyond the law to decide a case. In India, we follow the procedure established by the law. Here, the judges will punish a person if that person has violated the law, or the judge may declare a law ultra virus if that law has gone against the spirit of the constitution. You can also understand in that way. So if liberty is defined as a lack of governmental constraints, then all laws may conflict with liberty. But such is not the truth. if it is wrong for the government to deny an individual's right to do something, even when even when that denial serves the common good, then general right to liberty can truly exist. Right. What does it mean? So let me again take 1 minute break. Theory, it is not so easy to understand and make it to understand, others. So let me take 1 minute break and I come back. Again, welcome back. Now, if liberty is defined as a lack of governmental constraints, then all laws may conflict with liberty. So, what it means? If rights are beyond the law, then certainly law will have problem with individual rights, right? But such is not the truth. If it is wrong for the government, I'm sorry, just delete that. Such is not the truth. What I said, that if rights are beyond the law, then certainly law will have problem with the individual's right. So if it is wrong for the government, if it is wrong for the government to deny individuals right to do something, even when the denial serves the common good, right? So if the government denies the individual to do something because there is a issue of common good, and if it is wrong, if the state cannot stop an individual to do something, even when the direction of the state is just because it is related with common good, right? If this it is wrong for the state, or it is wrong for the government to deny the individual right, then the general right to liberty can truly exist. So to Dworkin's, is a, you know, Dworkin's concepts individual rights as being very fundamental. I mean, he is a very, very, you know, fundamentalist. I mean, in that sense, so he is not able to, compromise individual rights for the common good. Right. So what he's saying, that even if the state is right in directing the individual not to do certain things, right? The state should not do that, because individuals do have rights, and their rights are moral, their rights are beyond the law. Now, general right to liberty is possible only when rights are related with the equal concern and respect. Now, this is something that Dworkin has learned from John Rawls, that rights, you know, rights are no doubt, it is moral, rights are beyond the law, but rights are not beyond equality, right? So, Dworkin learned from John Rawls that rights are related with equal concern and respect. Right? Rights cannot be against equality. Rights cannot be against the respect. Now, right to equal concern and respect can be understood in two ways. One is right to treatment as an equal, or and second, right to equal treatment. The first is the right to treatment as an equal, and second, right to equal treatment. Both are not same. The first one is very fundamental, right? The second one, that is right to equal treatment, it depends in different circumstances, different situation. Now, if individual rights derives its power from the right to treatment as an equal, then individual right do not conflict with liberal understanding of equality, right? I'm repeating, if individual rights derive its power from right to treatment as an equal, then individual right do not conflict with liberal understanding of equality. I said earlier that Dworkins do not see liberty and equality uh, conflicting with one another. He's saying that liberty is related with equality because you cannot think about right without equality, right? If rights are related to, or if rights means right to treatment as an equal, then liberty is strongly connected with equality. Now, in this sense, if the government does not take rights seriously, then it does not take law seriously. Dworkins. So, if rights, this is the argument of Dworkins, if the rights means right to treatment as an equal or right to equal treatment, if right means this, right, then rights is strongly connected with the equality. Now, in such a situation, if the government does not take right seriously, if the government does not take individuals' rights seriously, then the government is also not taking law seriously. So, law must protect those rights which are related with self-respect of the individual and dignity of the individual. And again, the self-respect and dignity of the individual is possible only when right will become right to treatment as an equal and right to equal treatment. In such a situation, if the law goes against the right, then I mean the state, if the state goes against the right, then the state goes against the law. It means if rights means right to treatment as an equal right to equal treatment, then right becomes law as well. Now, many people agree that right to follow one's conscience exists even when doing so means violating the law. I said when the wife of that faculty started beating her husband with a sandal, now the society will stand with the wife because society is guided by the conscience. And society is not guided by the law, right? Now, if the society is guided by the conscience and not by the law, then society cannot be legal. Society cannot be legal. In fact, we all in this society, we are guided by our conscience, not by the law. Right. So I'm repeating. Many people agree that right to follow one's conscience exists. Right, every individual must be guided by their conscience. Even they are doing things against the law. That wife of the faculty member, she was guided by her conscience and started beating her husband with the sandal. But legally it was not just, but from conscience point of view, it was absolutely a just action. It was moral. It was not legal. But people do not agree that person should not suffer punishment when they exercise their conscience. Right. Now, society will support the wife of that faculty, but society will not support if the wife will claim that I should not be punished because I am guided by my conscience. Society will not accept it. Right. So this is the paradox, you know, in people in society. So people do not agree that persons should not suffer punishment when they exercise their conscience. People can understand it, but people will not support it. I mean, if you are having a lawyer kind of conscience, and if every individual will be guided by their conscience, some, in some individual conscience are higher, in some individual conscience are lower. So if the individual is guided by his or her lower conscience, then punishment must be there. Punishment must be there. So merely guided by conscience will not help you to save yourself from punishment. So people will not accept it. So people feel law should prosecute even in this case. Right. Even the individual is guided by the conscience, people will support the law must take its own course of action. Right. The confusion arises when people conflate two senses of the word right, right to do something and something being right to, or something being the right thing to do. So one contradiction one can see in this example, that people support conscience and people also support that the law must take its own course of action. Why this confusion happens? That this confusion happens because people conflate two senses of the word right. One is right to do something, and something being the right thing to do. Right? You have right. You have right. That doesn't mean that you can do anything. You have right because you are supposed to do the right things. You are supposed to generate good values for the society, even if you are going against the law. So if the individual exercises his rights against the state, against the law, but he or she create a greater values for the society, for the next generation. The judges, the Supreme Court, judiciary will consider that right of the individual. Right. So people will be very happy when the wife is hitting to the husband with the sandal, because that society is very critical about the action of the husband, because husband has done something wrong. Extramarital affairs is not accepted in the society, but at the same time people are also with this position that wife must be punished, because hitting to husband and beating any person is also morally wrong. So if you want to enjoy your rights against the state, then you have to produce a greater values for the society. Only then you have rights against the state. Now a person has moral right to disobey the law whenever it improperly encroaches on his rights. Now if the state is going against the individual right, then the individual may disobey the law. Otherwise, Dworkin is with obeying the just law. Dworkin is against obeying the unjust law, because Dworkin thinks that individual has right against the unjust law of the state. Now, these moral rights recognizes human dignity, respects political equality. I have said it before, right? I hope you got a sense. So let me summarize it. Now, Dworkin conceives individual right as being fundamental. Dworkin's conceives individual right is very fundamental. That doesn't mean that individual is free to do everything. Just now I said. It is being derived from an abstract right to equality being fundamental. They cannot be overridden by the government except in the extraordinary circumstances. As such, they are worthy of great respect. Right? Now, Dworkin is saying that rights means right to equality. And right to equality is related with the human dignity and self-respect of the individual. Right? So if the the state cannot override those rights, because rights are related with the human dignity. Rights are related with the self-respect. Rights are related with the equality. Rights are related with the law. Once it is related with the equality, once it is related with the human dignity, self-respect, then it is related with the law. Hence, government or the state cannot encroach upon the individual right until and unless there is some special circumstances like emergency. Now, what respect means in this context is best illustrated by virtue of comparing individual rights against collective interest. Right? Individual rights are respectful, it is because individual rights may go against the collective interest. The 99 individual can be false, one individual can be right. Right? Now, for Dworkin, individual rights ought to trump collective interest. That is, they also take precedence over the collective interest in circumstances in which collective interest might dictate that particular policy or proposal be pursued. So, I'm repeating things. So it means individual rights are prior to the collective interest. If those collective interests come into conflict with individual right, then for Dworkin's, the individual rights ought to take precedence over the collective interest. Because individual rights are related with dignity, self-respect, equality. That's why individual rights must prevail upon the collective good. Now, government, as far as possible in the Western liberal democracy, ought not to be predicted, and its policy ought not to be based on any controversial understanding of human good. Instead, as much as possible, governmental policies ought to be loosened from those controversial foundations. It means that Western liberal democracy, they have a controversial understanding of human good. They think that the 99, if the 99 individual they opt for a things, then that is just. Now this is a controversial understanding. The collective good, the common good may not be right, even if it is decided by the majority many. Remember, one individual can be right, 99 individual can be wrong. Now this is a controversial understanding. That's why this legal positivism, it holds that idea. Dworkin is challenging the legal positivism. Dworkin is challenging the Western liberal democracy, the assumption of Western liberal democracy. Right. So this is it. I think we should take right seriously. It is because rights are related with self-respect, dignity, equality, and rights also create greater values for the society. Hence, individual must have right beyond the state or law. If individuals are limited by the law, then the right of the individual may not generate or may not fulfill the purpose of right. The purpose of right is to create greater values for the society. And in this sense, I think Dworkin is making sense that individual should have the right against the state, because one individual can be right, 99 individual can be wrong. So thank you very much.